very much for not only that kind introduction, but for inviting me to be with you today. I also want to thank former Chairman Dick Wiley for reaching out and extending the invitation to tighten, needless to say, at the communications bar with a distinguished career in not only the private sector, but his public service. And I'm honored that he thought of me to come in and one of his former colleagues, Brian Pandia, who was mentioned, and I should note, not only is he a great lawyer, but he helped us in the trial. He was embedded in our Sabre Fair Logics trial, which is going on in Delaware, and closing arguments are tomorrow. But Brian took depositions of 4 witnesses, and the chief of staff of that litigation team came to me and said, "He's fantastic. Is it okay if we ask him to take some witnesses during the trial?" I said, "Absolutely." We talked to Brian. And then, lo and behold, the litigants dropped all of his witnesses from the trial. And you guys know what that means. It means he was just too damn good in the depositions, and those witnesses had no use to the defense. So that's a great honor to work with them and a number of colleagues that are in the audience. There's a lot of intrigue, especially recently, within the Justice Department Antitrust Division. A lot of people have been chatting. Some members of the media are here, so I just wanted to address that. My old colleague, Brinkley Captain, used to be in the front office at AT&T, is here as well, and she had been part of some of this intrigue. People want to figure out how we title our public speeches, or my public speeches. They often start with a song title. And I want to let you know that there is no real magic. We ask the front office counsels for suggestions. We look at the theme and see what fits. And today's speech is titled, "Getting Better" by the Beatles. You guys may recall, and this will make some sense. "You're holding me down, turning me around, filling me with your rules. I've got to admit it's getting better, a little better all the time. It can't go no worse. I have to admit it's getting better, it's getting better." It says so since you've been mine, but you haven't been mine. So some of these new rules. So today, I wanted to discuss the merger review landscape. I come to celebrate some major successes in making some changes to our rules, but also to identify a potential for alarm. Bill Baxter, a distinguished predecessor of mine as the head of the Antitrust Division, and roughly a contemporary of Dick Wiley's when Dick was the head of the FCC, noted that mergers, quote, "are an extremely important and valuable capital market phenomenon, that they are to be in general facilitated, and that it is socially desirable that uncertainty and risk be removed whenever possible to do that, to do so, subject, of course, to the very important limitation that where a merger threatens significantly to lessen competition, it should be halted," end quote. It's hard to disagree with the great Professor Baxter, who was President Reagan's first head of the Antitrust Division. My job as an antitrust enforcer is to create a merger review landscape that allows enforcers to stop harmful mergers while also allowing for the efficient resolution of investigations of completely beneficial or competitively neutral mergers. This brings me to the successful effort that I would like to report to you, if you indulge me. About a year and a half ago, I outlined a series of reforms that the Antitrust Division would undertake to modernize the merger review process. As a benchmark to measure success, we committed that we would aim to resolve most mergers within 6 months of filing. That is, provided, of course, that the merging parties cooperated expeditiously and complied throughout the process. As part of those reforms, the division published a model timing agreement, which in addition to providing much needed transparency, significantly changed how the division approaches so-called second request investigations. After, among other things, the new timing agreement limits the number of custodians and depositions that the Antitrust Division seeks in a second review, and commits the division to deciding significantly faster than the previous norm. In return, the timing agreement requires merging parties to produce documents and data earlier in the process. We also published for the first time a model voluntary request letter to allow for merging parties to anticipate and collect the information and documents that the division would need to make an informed decision. Getting that information to the division during the initial waiting period often allows the merging parties to avoid a second request or to significantly narrow the scope of such second request and narrow the burdens. By publishing these, we increase transparency and put all merging parties on an equal footing. We now have data showing nearly a year and a half of results. I'm happy to report that we consistently have been meeting or beating our pledge of completing the investigation phase of our merger reviews and informing the parties of the division's position within 6 months. In all merger investigations, the average time from the merging parties filing an HSR to the division, notifying the parties of the division's position, is 5.4 months. The merger investigations resulting ultimately in a challenge, whether a litigated court challenge or a negotiated remedy, the average time to notification is 5.7 months. Once we notify the parties of the division's position, one of three things can still happen. First, the division can report that it has no concerns and the deal can close, of course subject to other regulatory reviews. Second, the division can inform the parties that it believes the transaction is anti-competitive, and the parties can offer a divestiture or some other fix for the division to consider. Third, the division can inform the parties that it believes the transaction is anti-competitive, and the parties can seek a meeting with the front office to discuss what path there might be forward. Of course, additional discussions regarding the proposed fix or a meeting with the front office could add some time to the review. Not every merger can be solved in 6 months. Parallel investigations, whether with a sister agency like the FCC or a foreign enforcer like the European Commission or China's SAMR, typically take longer than 6 months, often because of factors outside of the division's control. Mergers that must be remedied with an upfront buyer also take longer to resolve. The division performs due diligence on the divestiture buyer, as you could imagine. Additionally, the merging parties themselves exercise significant control over the timing of the merger review process. If the merging parties are slow to produce documents or provide data, then that necessarily will slow down the review. Likewise, if merging parties play games with the division, that also can slow down the process. In a recent significant merger, for example, the merging parties submitted woefully inadequate privilege laws. As a result, the division rejected the parties' second request compliance and required the compliance where the parties would certify and move to through the second request, and triggers the second 30 days. So we rejected that and required the parties to re-review the documents for privilege and produce remedial logs. This had the effect of adding several months to the merger review process. I don't want unnecessary delay, but I also will not compromise the division's ability to protect free markets and the American consumer. Indeed, we won't hesitate to challenge anti-competitive mergers. In fact, the division, as I mentioned earlier, is currently in trial seeking to enjoin Saber's acquisition of Fairlogic. Next week, we will begin a first of its kind process in the history of the Antitrust Division, an arbitration in order to protect competition in Novelis's acquisition of Alaris to manufacturers of certain aluminum products. For transactions that don't harm competition, we're moving quickly to complete our review and allow the market to function as fast as it can. Delay is a form of risk and uncertainty, and we have taken concrete steps to reduce delay to the full extent possible. That is a successful news to report. As I mentioned at the outset, however, I also am concerned about another recent development. That is the possibility of third parties undercutting federal enforcement decisions, which is currently at risk in the proposed merger of T-Mobile and Sprint. As I'm sure many of you here are aware, the Antitrust Division and a great group of 10 states partnered with us. We reached a remedy. We had a settlement that is currently pending before the district court here in DC. That settlement, if approved by the court, would permit T-Mobile and Sprint to merge, but would require substantial divestitures to Dish. We agreed to this settlement because it meets the twin goals of antitrust remedies. It allows consumers to benefit from efficiencies associated with the merger while protecting consumers from the potential harms that would otherwise come from a lessening of competition. Of course, as many of you in this room also know, the Antitrust Division was not the only federal agency to evaluate this transaction. As it does with all spectrum license transfers, the Federal Communications Commission reviewed T-Mobile's proposed acquisition of Sprint's assets. After thorough consideration, the FCC determined that in light of the parties' commitments to the FCC and the DOJ, the license transfers were in the public interest. In doing so, the FCC emphasized that the anticipated impact of the merger on high-speed connectivity was a matter of health, safety, and equality for rural communities. It also found that the divestiture of Boost to Dish in particular, along with the MVNO arrangements, will allow currently underutilized spectrum to be placed in the hands of American consumers. What I've described so far is nothing new. The Antitrust Division, state attorneys general, and the FCC all regularly review telecom mergers. We often work closely with our state attorneys general partners in enforcement actions. Here, however, a small group of state attorneys general did not reach consensus. Although a good group of states joined the Antitrust Division in settling, a minority of states sued to block the transaction. These states asked the Southern District of New York to issue a nationwide injunction preventing the merger. The trial in that case took place in December 2019. The closing arguments were January 15th, and the decision is yet to be issued, but is highly anticipated, not only by the division and the parties, but I'm sure the many in this room. So we have two specialized federal agencies reviewing that particular transaction. Each of these specialized agencies has considered the pro-competitive as well as the anti-competitive effects of the transaction. Each agency has negotiated nationwide relief to prevent harm from the merger. One of these federal agencies is also moving in federal court to approve that nationwide settlement. Yet we have a minority of states and the District of Columbia trying to undo their relief across the entire country. If you find this situation odd, you're not alone. Part of the challenge of addressing a nationwide mobile wireless market was balancing the interests of rural and urban populations. Historically, rural populations have been underserved by the big four mobile wireless network providers. With this mergers and associated commitments, however, rural populations will see increased competition. That increased competition will occur because the FCC has required T-Mobile to cover 99% of the population with 5G connectivity. The Antitrust Division's remedy builds on T-Mobile's commitments to the FCC and protects urban competition by requiring the divestiture of Boost Mobile, among a number of other divestitures. This is a win-win situation that permits rural residents to benefit from the merger's efficiencies while simultaneously protecting competition for urban residents. Unfortunately, the scenario that has unfolded here is incompatible with the orderly operation of our antitrust merger laws and the telecommunication rules. It creates the risk that a small subset of states, or even perhaps just one, could undermine the beneficial transaction and settlements by two expert agencies nationwide. That is why the Antitrust Division and the FCC jointly filed a brief in the New York litigation opposing these states' requested relief of nationwide injunction in that particular transaction. I want to be clear about what our position is, but also crystal clear about what our position is not. Our position is not that states lack standing to sue for antitrust violations. In fact, the brief that we filed, SDNY, explicitly recognizes states' standing, their quasi-sovereign status, and their ability to represent their citizens in a parens patriae capacity. Our position also is not that the states are barred from seeking different relief than the federal government in merger reviews. We welcome the states or any other private party requesting a remedy in a merger case, either where the Antitrust Division does not act or where they seek relief that does not conflict with the Antitrust Division's relief. In fact, when we were moving to extend the Live Nation consent decree just last month, the division did not oppose a number of states requested incremental relief, and we worked closely with them for over a month to reach a consensus resolution, which was entered by a judge here in DC within 2 days. Additionally, I should note in a 2018 brief that the Antitrust Division supported the right of a private party to seek a divestiture following a merger that the division had not challenged. Instead, our position consists of three straightforward and related points that flow from Supreme Court precedent. First, Congress created states as private parties for purposes of antitrust enforcement. This means that states are required to meet a higher standard than the United States when seeking equitable relief in a merger case. The Supreme Court has consistently reiterated that position, including in the American Store's opinion in 1990. Second, where the United States has already secured relief in a merger case, a court must take that relief into account. This also follows directly from Supreme Court precedent, including the court's 2010 opinion in Monsanto and its antitrust-specific holding in BMI versus CBS. Third, courts should not award any private party, including the states, relief that is incompatible with relief secured by the federal government. This, too, has been well-settled Supreme Court precedent for 75 years. This is the only position that makes practical sense given the statutory structure enacted by Congress for merger reviews. Because what would be the alternative? That any state or even any individual can undo nationwide relief secured by the federal government and approved by a federal court? That would wreak havoc on parties' ability to merge, on the government's ability to settle cases, and cause real uncertainty in the market for mergers and acquisitions. Permitting states to undermine federal enforcement also would be contrary to congressional intent. When debating the Clayton Act over a century ago, and that's the antitrust law specific to merger reviews, the Senate considered allowing state attorneys general to, quote, bring suit in the name of the United States to enforce any of the antitrust laws, end quote. The Senate, however, decided not to grant this right to the states. This decision reflected concerns that the, quote, great danger of having a diversity of conclusions, end quote, and the possibility that it could, quote, prevent the carrying out of any uniform policy in the enforcement of the antitrust laws. That concern resonates particularly strongly in the telecom industry, the industry which many of you practice in, given that it is not just uniform antitrust at risk, but also national telecommunications policy set by a separate federal agency. This is not a new argument. It is the same position that the Antitrust Division took 25 years ago in the Microsoft case, and has been the bipartisan position of every administration since that time. As my predecessor and friend, former Assistant Attorney General Bill Baer explained, quote, federal and state competition law enforcers have similar missions. Both protect the public from the harms flowing from anti-competitive conduct. But federal enforcement seeks to protect the interest of all consumers across the nation, while state enforcers understandably focus their efforts on the consumers in their respective states. End quote. It is for this reason that the idea has always been that these, quote, enforcers should play different yet complementary roles. I share former Assistant Attorney General Baer's commitments to this complementary enforcement regime. Part of that commitment is protecting the nationwide perspective that the Antitrust Division and other federal agencies bring to merger reviews involving national markets. In the T-Mobile Sprint matter in particular, we continue to believe in the strong disruptive potential of a combined T-Mobile and Sprint, and of Dish. We look forward to securing those benefits for all American consumers. I hope that these remarks today have shed some light on how the Antitrust Division views its role in merger enforcement and given you some food for thought as we navigate a complex enforcement landscape that involves not only dual, but triple, it seems, enforcement, perhaps 54 agencies altogether in the United States. So I thank you for the invitation to share these thoughts with you, and happy to answer a couple of questions if you have them. Thank you.
We have one back there.
Leah, how are you?
I'm good. How are you? Leah Mylan from Politico. One of the things the Justice Department has been working on for a while is the review of the Asst and BMI consent decrees. I wondered if you had any update on when you guys might be reaching a decision.
No real updates since I think the last public comments I had made at my Senate Judiciary Oversight hearing. We have gathered all the comments. Staff is going through the public comments that were provided. We continue to meet with anybody who is interested and hear the various viewpoints. We fully recognize their continued relevance in the market, as we have said before, and those would be factors we consider. The staff will be sending kind of their considered judgment of the public comments, and to the front office, we will take a look at that point, probably begin a discussion with the affected parties, which I continue to learn and understand that affected parties continue to be more and more, including funeral homes and wineries and bowling alleys and hair salons, studios, and all of that. So we know the broad implications it has, but we haven't made any decisions. Frankly, we haven't gotten the staff's recommendations on those yet.
Hey, Margaret McGill with Axios. A question about the upcoming, I think it's a workshop on Section 230. I'm curious what the Antitrust Division's interest is in that statute, and what the goal is of that workshop.
I would refer you to the public affairs. It's being handled out of the Deputy Attorney General's office, Section 230, given the broad implications. It doesn't directly implicate the antitrust laws, but obviously it's an important policy issue that affects some level of competition. We're providing resources as needed through our policy shop on that. And so they'll be working closely with the Deputy Attorney General's office, but I'll refer you to that.
Deborah, some of the executives of the platform companies like Facebook and Google have said that they want government regulation. And my question is, do you think existing antitrust law is capable of dealing with the platform companies? And if not, are you considering any kind of regulations in response to their request for more government regulation?
As a general matter, one I'd refer you to Cecilia's fine work in the New York Times that reported on 9 recusals from some of those investigations. But I would also refer you to a couple of speeches I've given this past year, just generally over the policy, not with any particular company about that. But most importantly, we are the enforcers of the law. We don't issue regulations or issue legislation. I'll refer you to Article 1 for that, or some of the other agencies that do Article 1, 2, and 3 in the same agency.
Gary Shapiro, Consumer Technology Association. I greatly appreciate your bringing back some certainty to the timing process, because these lengthy time periods are very deleterious to business. And I don't know why it would be good for the public, but I appreciate your focus on that. And I used to be an antitrust person, and I'll confess this might be a very foolish question because I don't follow it that closely anymore, fortunately. But there used to be something called review guidelines where you had certain percentages of market share. You kind of knew whether you were safe or not, or you had the business review letter process. Any thought to bringing back a little certainty? And I harkened back. I know it wasn't the Department of Justice, but it was the FCC and the last AT&T attempted acquisition of T-Mobile, where basically, all the legal talent in the world couldn't come up with a legally certain answer from one sentence from the FCC chairman, which destroyed about $4 billion worth of value, handed over to T-Mobile by AT&T. And I'm just curious if that's something that, any thought to bring back a little certainty to the process in terms of market share and various factors?
Great question. So, 2 quick answers. You're probably right. That breakup fee probably created more competition than anything the Antitrust Division of the FCC has done in this field. And creating more competition with the transfer of not only the money but spectrum. But the horizontal guidelines have been updated. They were put in place by Bill Baxter, but then every time we have some new case law or better understanding of the economics and the econometrics involved in these, we've updated them, and most recently, I want to say about maybe 5 years ago or so. So they seem to provide some, try to create as much, for lack of a better word, guidance and certainty for parties to understand that. The one area that, the AT&T T-Mobile was the FCC, but my predecessors had brought also the case in the district court, so there was a lot that was going on around the same time. The other area that there's been some uncertainty, and you might be referring to yet another more recent transaction by some of the same companies, is the vertical area. And we just issued jointly, and we've been working on this for over 2 years. We just issued guidelines for vertical mergers, and those have been in place since 1984, not referred to or provided any certainty. Frankly, it probably was incomprehensible to most, and so we withdrew those. And we issued draft guidance. We're getting public comment, and to be honest with you, I don't know exactly when we put those out. I think January 10th. Is that right, Dave? January 10th, and I think we just extended the time period to 45 days of public comment. We're going to hold a public workshop on those guidelines to understand